All right, we'll call our next case this morning, which is Samuel Holmes and Standard Parking versus Leonard. Good morning.
Good morning. May it please the court, Rosemary Wilder and Arthur England, representing the appellants Samuel Holmes and Standard Parking. Unlike the case you just heard, this case does not involve fundamental error based on completely recognized improper closing argument. In this case, the defendants were deprived of a fair trial because of the scripted and pervasive comments made by plaintiff's counsel, denigrating the defense and attacking defense counsel, diverting the jury from the evidence, and this is the very conduct that has been condemned by virtually every court in Florida, especially this court, and this court has even gone to the extent, with comments like the ones made in this case, to find fundamental error after Murphy versus International Robotics. But that's not really an issue we have to deal with in this case.
Is there any fundamental error argument or issue here because certain of your objections were not properly preserved?
No, I don't believe so.
So every objection that you're complaining about is something that was made and preserved?
I think, no, let me try to clarify that. There were 6 sets of objections made to the most egregious comments, starting with the refusal to accept responsibility, characterizing our defense as frivolous, accusing us of spying on the plaintiff and causing further injury because he had PTSD. Those objections are at 2404 to 2405 in the record were overruled. There was a golden rule type argument made at 2419 that went on for 3 pages, with the trial court trying to explain to California counsel that in Florida these kinds of arguments are not allowed. He ultimately just says to him, move on, and points out that if he continued in this vein, it was possible that the plaintiff would be having to face another trial, something the trial court did not want to have to do. The next set of
And when these objections were made, were they accompanied by requests to give a cautionary instruction and or requests for a mistrial?
When the objections were sustained, of course, obviously the ones that are overruled, they don't have to be. The ones that were sustained, yes, there was a request for the curative instruction. We moved to strike, which is asking for a curative instruction to the jury, and the most egregious comments having to do with our refusal to take responsibility, asking the jury to give an improper or unjust verdict of only 10% of what the plaintiffs had asked for, and then, of course, the comment that is the centerpiece and the most egregious one, where the plaintiff's counsel in closing says, if you agree with Mr. Adler, defense counsel's numbers, I can guarantee they'll be celebrating with champagne in Miami. There's an objection, a motion, it's sustained, there's a motion to strike. We then also later on made a motion for mistrial, which was taken under consideration by the court and then ultimately denied. These first sets of comments, which are
after the closing argument finished.
Yes, that is correct. But as we pointed out, the Supreme Court in Campiani ruled that the way to preserve the objection is to make the objection, and if it's sustained, to either ask for the curative instruction, which is what we did, or move for a mistrial. We did both. We just asked for the curative instruction timely at the time the objection was made, after the objection was sustained, and then later on moved for a mistrial, which the court took under consideration and later denied. There certainly were improper other unobjected to comments, such as the fact that we had a contrived defense counsel was being really slippery when we tried to sell the fact that the plaintiff became his recovery was very quick, a very strong, solid recovery within months after the accident, asking the jury to figure out what defense counsel was trying to pull, and at the very end of rebuttal to send a message comment that if the verdict wasn't for the plaintiffs, they wouldn't be telling the defendants and the defense that they need to be held responsible for the accident and the injuries. Those comments probably could be fundamental error, standing alone with nothing else. But what we have here is more of a situation like we had in Pinheiro, where you've got three sets of comments. The first set of comments was a comment that is so parallel to this case, where they say in a personal injury case, the plaintiff was injured after a high-speed chase by a City of Orlando police officer. And in closing, they say to the jury that the City of Orlando is not going to be held responsible unless you find a verdict for the plaintiff. And if you don't do that, then the city will be going back, and what's going to be happening is they were going to be laughing at the verdict outside of the courtroom, in the elevator, in the garage. And I think basically what you have here is the same exact thing. A, the charge of failing to accept responsibility, which in some cases standing alone is a reversible error, but failing to accept responsibility for the accident, and that if you don't find for the plaintiff the verdict that they're asking for, the defendants are going to know that they made fools of you, that they pulled the fast one on you. And that's exactly what we have going on here. Is that same kind of comment. They're going to be laughing at your verdict because there's no question that, coupled with everything that started from beginning to end in these scripted comments about the frivolous contrived defense and all of these other comments that were made, it was clear that what they were saying was the defendants are trying to pull a fast one. I mean, that's basically it. They're trying to fool you and make you look ridiculous if you accept their verdict. And that's exactly the kind of thing that happened in Pinheiro. Now, in Pinheiro, they went on to look at send a message comments and said, well, standing alone, this would not be a reversible error.
In the Pinheiro case, like this case, I mean, that case didn't turn on that one comment. There were a whole series of issues. And I mean, there's no question that in Pinheiro that was a significant issue, but there was a whole range of issues. And do you agree that the standard of review that we look at is abuse of discretion?
Yes.
The trial courts?
Absolutely. And in Pinheiro, you found reversible error based on the laughing comment. That's the first thing you found. You found that comment required a new trial. Then you looked at the remaining comments, said those comments standing alone would not require a new trial, but it's of no moment because those comments simply support the fact that the laughing outside of the courtroom comment required a new trial. And that's exactly what we have here. We have the exact same situation. And I think that when you look at the cases, especially from this court, I mean, 5 different times this court has ruled that these comments are improper. Most recently, in Health First versus Cataldo, virtually same thing, denigrating the defense, attacking defense counsel. You all said these are improper comments. It wasn't reversible error in Cataldo because there was not a single objection. But there were objections here, and more than enough objections to preserve that. But respectfully, even if we were arguing fundamental error, Judge Palmer, I think we would meet that test. Under your own cases, in service, you found post-Murphy fundamental reversible error when the attorney attacked the defense and the defendant. And you found fundamental error post-Murphy, which is difficult, but that's what you did. And I think that when you look at your cases, Pinheiro, which reversed for a new trial based on the laughing outside the courtroom, they're going to be laughing at you outside the courtroom comment. Service, fundamental error, post-Murphy for denigrating the defense. Right, the same thing, reversible error. An old case that used to be cited all the time, Erie versus Bushy, where you also found you found reversible error in a damages-only trial, and said that this court had no other alternative but to grant a new trial because the defendant had been deprived of a new trial. That's what we're talking about here. We're not talking about was there substantial evidence to support the verdict. As you noted in Service, there was overwhelming evidence to support the verdict in that case, and you reversed anyway, because of the comments made in that case. In Cascanet, this exact panel looked at the verdict to support the fact that the prejudicial comments, in fact, impacted the verdict, where the verdict was exactly...
There was a lot more in Cascanet. I mean, Cascanet was a situation where the young girl was a defendant and her father was vicariously liable, and he didn't show up for any of the trial. They had her dressed up really nice and innocent, but as the only person sitting at the defense table. And then the comment was, do you want to hold her responsible for this? I mean, that's different than what we have here.
Well, I think those facts are different.
That was a deliberate tactic to try and curry sympathy with the jury, and it was. I mean, I don't even see how. I mean, Cascanet to me is as clearly distinguishable from this.
Well, even if you distinguished it on the facts, the point is that you look to the verdict. You look to what the verdict was to see if the appeal to the jury, to the prejudicial and inflammatory attacks on counsel and defense affected the verdict, and that is exactly what we're saying.
The trial judge apparently didn't think so. Otherwise, he would have granted you the relief, right? And the trial judge sat there and listened to everything, the context of all these statements, the context of the argument, what the statements were directed at, and the context in which they were made, and he just simply thought that, well, yes, maybe some of them were inappropriate, but not enough to warrant a new trial. And now we have to say that he was wrong in making that decision, and he abused his discretion. That's not an easy standard for you to.
That is absolutely, I agree with that 100%. 5 times you found abuse of discretion when the trial court refused to grant a new trial for comments which this court has recognized are totally improper.
For example, I mean, you complain about the fact that they made the comment that they were spying on, that you were spying on their client, and I think that had to do probably with the surveillance films. Is that right? I mean,
exactly.
They could have said, well, they were surveilling my client, and instead they used the word spying. I mean, maybe it could have been phrased a little bit differently, but it seems to me that, when you surveil and you don't have the permission to surveil at their home or wherever they are, it's essentially what you're doing is spying on them, right?
Even if...
And that's what they told the jury.
Even if the comment had been limited to that, they're spying on the plaintiff, and that was all they said.
But, I'm just saying that's an example of one of the things you're complaining about, and the trial judge heard all this. He heard the context in which all these statements were made, and said that it just doesn't rise to the level of warranting a new trial.
And our point is, even if you take away the spying comment, we're still left with, you're looking in her bedroom window, you're following the daughter, you're trying to get pictures of young girls scantily clothed in the gym. Those are not the overall surveillance kind of comments. And taken together...
Surveillance is it seems to me it's a standard defense technique these days. Everybody surveils so that they can try and catch the alleged injured party doing that which they say they can't do, and then that creates a powerful influence on the jury. But essentially what you're doing is surveilling and spying on them. I mean, they don't know you're doing it.
And that's all fine.
That's just an example. I mean, and so what I'm saying is that it seems as though that if you look at everything in the context in which it was made, and then you look at the verdict that the jury rendered, I mean, I can understand how the trial court came to the conclusion, well, it didn't rise to the level of warranting a new trial, and that it wasn't so prejudicial based on the evidence and testimony as to the damages to set it aside.
Respectfully, Your Honor, I think when you look at your own cases, and if you really mean what you said in those cases, like Cataldo, which says this is improper argument.
Each case turns on different facts and circumstances, and we read the record, and we review it. For example, Caskinet is a perfect example where you said that constitutes a basis for us to reverse, and I think that's clearly distinguishable. I don't even see how that case applies in this case.
Well, we were citing it for the principle that you look to the verdict, and in this case, where the jury gave the plaintiff virtually every single award they asked for in the amount they asked for it, in Caskinet, you found that supported reversal for a new trial, and that is what we're citing that case for. But we've cited and given you dozens of cases where the exact same kind of comments.
Coming back to the Orlando case, the city of Orlando, the comment, they'll be essentially laughing at you. Well, I was on that panel, and I remember that case. We went to great lengths to say that was an improper comment. I was just looking at the case here and reading it over very quickly. I don't see anything in that case where we said that comment alone, it should reverse the case. We did, no question that we wore the attorney out for making a comment and said it was improper. But I don't see, and maybe you can point me to something that says that comment alone is a reversible issue. I just don't see it, and you can think about it on your rebuttal time. You're down to 4.5 minutes.
Yes, because we have that in our reply brief, and I will bring that up.
And it may just be that I've just scanned it too quickly. Good morning, sir.
Thank you, Your Honor. May it please the court, I'm Michael Korn, along with Joshua Whitman, who's seated at the council table, and Dennis Scoville of San Diego. We represent the appellees in this case.
Are any of the comments improper? And is your argument simply that it doesn't rise to the level of an abuse of discretion? Do you concede that any of the things that were done at trial shouldn't have been said? And if so, which ones shouldn't have been said?
Well, Your Honor, obviously I would respect the trial court's discretionary rulings, whereas some of the comments that were made where objections were uttered and the objections were sustained, I think we have to accept that as, in essence, as a de facto law of the case, that at least the trial judge sitting as the referee of the case determined that was an improper comment. But to your point, and you asked counsel earlier about whether all of the concerns that they had were either preserved or the subject of objection, and they clearly weren't. Much of the focus in this case, of course, has been on this the celebrating comment at the close of the rebuttal arguments.
You would agree that was improper, wouldn't you? Would you say that's improper?
Well, again, the trial court sustained the objection.
Okay.
But you don't agree with that because on page 33 of your brief, you say, it was fair comment on the failed defense strategy to minimize the plaintiff's condition and damages.
Not as to that comment. I think that may have been as to other points. What the point is this.
Well, I didn't really hear an answer, because in response to, is that improper, you say the trial judge sustained the objection.
And
that to me is different than saying, I admit that was improper, it should not have been said. Are you willing to say that? I
accepted the trial judge's ruling of it being improper, so how could I disagree with the trial judge? I think that's the same, respectfully, I think that's the same point.
Let me bring you back to the question that I just asked, where you said that your defense of that comment really didn't relate to that comment. If you read page 33 of your brief, plaintiff's counsel observed that if the jury was persuaded to award the damages recommended by the defense, their lawyers would be celebrating what they would consider as a job well done, popping champagne, etc. It was not suggested that they would be laughing at the Leonards of the jury. This comment was not a criticism or implied attack on the jury. It was a fair comment on the failed defense strategy to minimize plaintiff's condition and damages. You're telling me that that wasn't a comment on their strategy. You're defending that comment, which I find, frankly, I can't imagine a comment a whole lot more repulsive. Now, whether or not that comment is enough to get a new trial, different story. But you're telling Judge Palmer, you know, well, sure, we agree, the trial judge, it should have been wrong. Page 33 of your brief saying, oh, no, man, that was a good shot. That was a good, clean shot, not a hit below the belt. It's got to be one or the other.
Well,
Which side of the line are you on?
I understand why the council made the comment. I accept the trial court's ruling. I accept the fact that it should not have been uttered. That being said, if you look at the analysis of whether it was harmful, and of course Murphy would...
No, my point is more discreet than that. I'm asking you to explain to me your representation in the brief. It was a fair comment on the failed defense strategy. Give me some reasonable argument that makes that a fair comment on the failed defense strategy.
Well, the defense strategy in this case, you have to go back a little bit, and we try to...
The defense strategy was pretty simple. We're responsible, but he wasn't hurt nearly as bad as he claims. He's made a much better recovery. I mean, wasn't that the defense strategy?
In part, and the way that they tried to impart that was not to call any of the CMEs except for one that they had gone through the case with, and to rely on this surveillance video as being really the framing of what they thought was going to be able to show that Mr. Leonard was either malingering,
So far, this sounds like just about every other personal injury case all of us have ever tried. Only difference is, I mean, I agree that the way the accident happened is kind of odd, and the damages, no doubt, were very significant and life-changing for your client. But so far, you haven't said anything that surprises me, and you haven't seen 1,000 times before.
But to the point of the defense strategy, and I think it's significant here, this was a 9-day trial. The defense took less than a day. What the defense strategy was to try to attack Mr. Leonard. They attacked him by claiming he was a malingerer, that he had not made a good faith effort to return to work, that he had somehow shirked his responsibility to return to work, that he was really doing fine even though he had, as the record reflects, and it's undisputed, tremendous fractures throughout various portions of the body, causing neurological damage, ongoing pain, and really an ignoring of the psychological impact that this accident had on him. So what was the defense strategy? To try to put together a melange of videos of him getting out of a car or working out as part of his rehabilitation technique. So it had, just as was said earlier in response to counsel's question, the case must be looked at not in a vacuum, but in the context of the facts as they were presented, which is exactly what Judge Traynor did in this case.
What about the comments about the surveillance? I'm not concerned about the word spying, but these references to maybe they're trying to take pictures of these women scantily clad. What evidence was there to support those comments, and what was the point of those comments?
Well, the evidence would have been that, and there was a photograph put into evidence that said, in the gym in California where Mr. Leonard was working out, says no photography, this is basically a private, place. And so the issue was really, what was the defense trying to do? Were they trying to pry? And that was an issue that came up.
But were they trying to take pictures of other people? Was there any evidence to support this context that there was something about the surveiller, that he was a pervert trying to take pictures of the other people? He wasn't trying to surveil the plaintiff?
We don't know. The record doesn't have the outtakes of what was not presented at trial. There was some testimony, however, to the extent that Mr. Kazwan, who was the videographer, the investigator in the case, had been given instructions on how not to take pictures of certain things that would not necessarily be helpful for the defense theory.
Well, that's got nothing to do with these comments about maybe he's trying to take pictures of scantily clad women, does it?
Not particularly.
There was no evidence to support that comment, was there, in the record?
There was, that he was attempting to do that. There were some questions that were asked of him, and I think there was one objection to that comment about that. And counsel moved on. I don't think it was even asked. I mean, it was asked, but not answered. Excuse me.
What about the peeping into his daughter's? I mean, I thought the testimony was that he was in his daughter's room, and so they were filming his interaction with the daughter. I mean, again, the sense that I get was that, you're trying to make this guy look, I guess to some extent, all surveillance videos are voyeuristic to some extent, but, that's the whole purpose, I guess, is to see the guy or the person when they don't know that they're being seen. I mean, it makes it sound very tawdry, though, like he's peeping on this daughter. I guess, my whole point is, opposing counsel says, well, you've got 5 cases that did this, this, and she's absolutely right, although every one of those cases has its own bumps and warts. We've probably got 500 cases where we don't do it because they're PCAs or we don't write on that issue or whatever, so, you can't draw that direct correlation. And when you have an abuse of discretion standard, what it really is going to come down to is the 3 of us sit down and we give this thing the smell test. And that's really what it comes down to. I guess, an abuse of discretion, I guess, ultimately is what we think it is. Can't do it. But I'm just trying to look at the cumulative weight of things that I look at and I say, this is really distasteful. This just isn't the way it's supposed to be done. And the champagne comment was pretty bad. The peeping in comment, I thought, peeping in the girl's bedroom, was a bad one. There's another one in the transcript where it says, defense counsel, and this is a quote, is real slippery in how they're trying to sell the extent of the plaintiff's recovery.
If I can address that comment, Your Honor. That was related to the testimony of the CME expert, Dr. Cantor, who was trying to, in our view, conflate the complaints of pain that Mr. Leonard was having, and the testimony that was presented by Mr. Leonard's physicians was that it was pain that was resulting from the healed but still jagged-edged fractures at L5 at the transverse fractures. And Dr. Cantor was trying to conflate that into, well, it could be a labral tear, it could be something at S1. And that was the context of the slippery comment, which, by the way, also was not subject of any objection whatsoever. Many of these were not the subject of any objection. And that's why, again...
Was the champagne celebration, was that objected to?
Well, it was objected to, but we believe it was not properly preserved, and here's why. That comment was made, counsel objected, the court sustained the objection.
And then that was it?
Well, I'll go forward, because, and then...
How about I'm just trying to hear what was objected to. How about the peeping statement? Was that objected to?
There was, the one comment was made that there was an objection which was overruled, where there was something about looking into the daughter's bedroom. So there was an objection to that was overruled. That was at page 2502. That was during the argument.
Did they move to strike the comment about the champagne?
I was trying to get back to that. This is what happened. The comment was made, and if I could, and we tried to say this in the brief, that comment was not just taken in isolation. That comment was, we believe, was a result of the door being opened by counsel during his comments, first by talking about that everybody was virtually certain was going to be going home the next day after trial. Everyone knew, because it had been established in voir dire, that the defendant's lawyers were from Miami, that the Leonards and their counsel were from California. Nobody was from St. Johns County. And so I don't believe that the geographic issue has anything to do with the comment. If there's a flaw in the comment, it was the celebrating with champagne part. So back to your question. It was in the context of that, because Mr. Adler said, I don't want you to punish or vilify my client. It was just an unintentional accident that Mr. Holmes hit the gas instead of hitting the brake after he had left the vehicle in reverse, instead of putting it in park, and when he tried to jump back in to stop it. So it was a purely unintentional accident, and you should not punish him. And that's when Mr. Scoville said, we agree you shouldn't punish him, but you also shouldn't give the plaintiffs less than full justice. And that was the prelude to the comment. Now, to your point about the objection. Objection was made, objection was sustained. Counsel said, I move to strike, and the judge said, I sustain the objection, move on, directing it to plaintiff's counsel, and he moved on. There was no motion for mistrial. There was no motion for a curative instruction. There was only until after the jury had retired.
Well, a motion to strike is in essence a motion for curative in the sense that if the judge grants it, the judge would say, ladies and gentlemen, the comment that you just heard about X was improper and you should not consider it.
Your Honor, and you know, in a perfect world, every trial judge would say everything the exact same way, you know, and say it to the pluperfect fashion. Here, we would suggest that the court's emphasis on that the objection had been sustained, move on, was tantamount to the signal to the jury that they should also move on and not consider that. And what's significant...
I don't disagree with it. I think the question is, does that preserve it for appellate review?
We do no.
I don't know what they could have done more than maybe shot up a rocket and say...
Well, because Campagnoni from the Supreme Court says that there must be a motion for mistrial. Doesn't say, and you have to read the case carefully because there's dicta in the case where they're citing to certain other opinions where there's the reference that they equate a motion for mistrial to a motion for a curative instruction. That's not what the holding says. If you actually go to the holding, and we have to assume the Supreme Court knows how to write its holding, they can write it as expansively or narrowly as they choose. They basically said, we hold that when a party objects to instances of attorney misconduct during trial and the objection is sustained, the party must also timely move for a mistrial in order to preserve the issue for a trial court's review of a motion for a new trial. If the issue is not preserved in this manner, then the conduct is subject to fundamental error under Murphy. So we don't believe that the motion for mistrial made after the jury had retired was sufficient. And there's a good reason for that. You know, when you ask for a mistrial, you're asking for a pretty drastic remedy. You are basically saying, we're ready to jump the 9 days of trial and not roll the dice on what the jury is going to do. So what the contemporaneous objection requirement really means is that the counsel's got to be really sure, is that the remedy you're seeking? You can't just sit back, wait, see how it turns out.
Well, they didn't sit back and wait to see how it turned out, right? I mean, it would have been one thing if they had moved for mistrial after the jury came back. But asking for it immediately or asking for it while the jury is out deliberating doesn't have any practical effect one way or the other, right? If the court's going to grant the mistrial, it's not like they're waiting to get a second shot.
Well,
right?
it doesn't have any effect on what I would call the judicial economy features. In other words, we went through the whole trial instead of going through a portion of the trial. I would agree with you on that, Judge Palmer. But we have to take the Supreme Court at its word. A contemporaneous, timely motion, we believe, was not made in this case, so therefore that issue was not properly preserved. And again, we come back to what I think is really the inherent issue in this case. Judge Traynor sat through the 9 days of testimony with a very attentive jury and a very engaged jury, which they claim was so attentive and engaged and took so many notes that they were this malleable that they could have been somehow improperly convinced to enter a verdict for the Leonards on nothing other than some type of prejudice against the defendants.
I'm trying to remember which were objected to and which weren't. And I think the Champagne comment was objected to.
Objected to but not preserved.
Okay, which other comments were objected to? They are complaining about.
Right. The major ones, they objected to the issue about an improper argument being frivolous. There was an objection to that one.
Is it wrong to characterize an opposing counsel's argument as frivolous?
They ought not to do that. Yes, sir.
Okay,
but again, we come back to does it go to the heart of the case? Does it go to the fundamental fairness of what happened during the trial?
Let me ask you about another statement. Go ahead.
I'm trying
Yes, sir.
to get, okay, it was so they objected to the frivolous, the Champagne, and what else?
Well, there was one that counsel didn't talk about it on argument. It's in the brief. There was they claimed that this was the golden rule argument. Mr. Scoville just basically started, if I put out an ad, that was all was said. It was a sidebar conference at that point. There was a colloquy between the court and
Okay, what else? What
and that was objected to, and he didn't go further. They moved on.
So what else?
The comment during closing about the bedroom window, there was an objection which was overruled. That was at 2502.
Okay.
I believe, Your Honor.
Everything else was unobjected to?
There was the comment about the slim outfits, but that wasn't during closing. That was early in the trial during the testimony of Mr. Caswan, the videographer. That was at 626. It was objected to, and that objection was sustained, and they moved on. And one other point that I think I really have to make is, and I was trying to explain to you why I think this case was really an appeal waiting for the trial to be over, was because the defense strategy, we believe, was flawed, and that Mr. Leonard suffered catastrophic injuries of really horrific nature.
Yeah, but it would have been better for you. That's why I asked an open-ended question. Did you think it was there? It would have been better for you, I think, in your argument, to simply say that, you know, the comment that they were going to go back and celebrate with champagne was improper and should not have been made. It would have been better for you just to say that, well, these comments should not have been made, but they didn't rise to the level of either fundamental error if they weren't objected to, or to take away this verdict. And it would have been much better for you, I think, and that we could have, you know, bypassed a lot of this discussion about whether it was improper or not. Had you just said, well, those are comments that shouldn't have been made, and here's why the verdict should remain.
But I think that's exactly, if I misspoke, I apologize to the court, but I believe that's what we were trying to impart, which was, were the comments all, you know, proper and should have been made? No.
Well, you were trying to support the champagne argument, but I mean, it'd been better for you just to say that, well, okay, it shouldn't have been made, and you know, that's something that counsel shouldn't argue to the jury, but in the context of the entire case, the verdict shouldn't be set aside. They're not entitled to a new trial because, and move on with that argument. But you were actually trying to, you know, to support that as something proper. It seemed to me like that's what you were trying to do.
Well, Your Honor, the analysis that you've done is precisely what the trial court did when he considered the motion for new trial and denied the motion for new trial, because the trial judge was there and knew what was going on in the courtroom. I have to just, in the short time...
Let me ask you about another statement that we haven't specifically talked about, in which it was said, as you decide what is fair and just, you will send a verdict back. You'll tell this defense team that they must take full responsibility for the harm done to this family. Is that a proper comment? Is the defense team supposed to take responsibility for the harm alleged against the defense?
Should not have been made, but was never objected to. Never objected to, and it certainly doesn't reach the fourth prong of Murphy. And if I could, just in 10 seconds, counsel said that the jury gave these plaintiffs everything they asked for. They most certainly did not. The only element of damages that was not agreed to, that they gave Mr. Leonard pretty much exactly what he asked for, was his past lost earnings. Future lost earnings substantially less than what was asked for.
Thank you, counsel. We saw those numbers.
Thank you, Your Honors.
We're going to have a delay of game penalty here in just a minute.
I tried to get him to do it. To answer the last question left over, in Pinheiro you said, however, in looking at a send a message comment, however, as we are obligated to reverse based on the inflammatory comment addressed above, this comment adds support for our decision. So in answer to your question, Judge Schreier, it was that single laughing comment that was the basis for the reversal for new trial, and the other error simply supported it.
A lot of your complaints about some of these improper comments weren't objected to. And I think it's appropriate to, you know, to ask if they were so egregious and so bad, defense counsel, you would have thought would have objected and brought that to the trial court's attention, but they didn't. And so, why wouldn't it be logical and reasonable for us to conclude that, well, okay, looking in the context of everything, they didn't think that it rose to the level of being so egregious that would warrant an objection, and we look at it and we come to the conclusion, well, maybe they were wrong, but they weren't so egregious to warrant a new trial. Why wouldn't that be an appropriate avenue for us to take in looking at
I
this
think
now.
that if we hadn't, and they've now admitted, the 5 or 6 most egregious comments were objected to. They were objected to. And most of them were overruled, or the court said, move on. And I think that as I mentioned before, the unobjected to comments, like the send a message at the very end of the case, the really slippery, those were not the most egregious comments. And I don't think we are obliged to be jumping up through closing argument every single time they pull out of their bag of tricks one of these comments. I mean, we're doing the best we can, we have to pay attention, it's a long case, it's a long trial, as you all know.
I mean,
But-
if it's a comment that's so bad that you think prejudices your right to a fair trial, you should object. And a lot of these you didn't.
I wouldn't say,
And so then that brings it to the question, did they, does
I don't-
rise level of fundamental error? And
I don't think it's a lot. I think there's 4 we didn't object to, everything else we did. We didn't object to the contrived defense comment, we didn't object to the really slippery comment, we didn't object to what they're trying to pull, and we didn't object to send a message. But that's just 4 of the comments made in closing. Everything else was objected to. And you have to remember, we admitted liability
You
from the
said
beginning to
before,
the end.
you said before that we made an inference that, well, the jury was so persuaded by all this that they basically gave them everything they asked for, and that's not the case here.
Yes, they gave them the exact,
Okay, go ahead.
I'm sorry, the exact amount for past pain and suffering, future pain and suffering, the exact amount for past medicals, virtually the exact amount for future medicals. What they didn't give them, they gave them the exact amount for past lost wages. What they didn't give them, which he said was the substantial reduction, was future lost earning capacity, where they had asked for, I think, 1.3 million, the jury gave 800,000. Totally understandable if it was not influenced by something else, because this man worked for 7 months full-time, stopped working, and never looked for another job in any way, shape, or form. So that was the basis of that reduction. What we're saying is that whole verdict could have been far less had it not been influenced by the prejudice in this case. And in conclusion, I would just ask the court, if you've got the time, if you look at that surveillance video for 5 minutes, you're going to understand what all these comments are about and why they found it necessary in a case of overwhelming evidence to use this kind of strategy to get the verdict that they got.
The jury
And-
saw that tape, I mean.
Exactly, and if
I mean,
you see it.
I mean,
it's-
obviously, it was a tape that was
If-
in your favor, but the jury saw it. and-
Exactly, if they had seen it and not been
And
exposed to all these comments, we think the verdict would have
And
been
you're
totally
saying, and you're
different.
saying that the jury made these awards simply because of these comments and closing argument?
Yes, that's why they're always found to be improper. They're always found to be improper. And in conclusion, they're still arguing that the Champagne comment was not a comment directed at defense counsel, and it was fine. But I submit that if I tell you right now that if you affirm this verdict, the plaintiffs will be in Jacksonville drinking champagne and laughing, you would understand that that's a comment about defense counsel and not a comment on the evidence.
So with that, I think we'll go break, and I'm going to have a shot of Jack Daniels during our break. Thank you all so much.